they want, over $1,000 in child support from me, but they don't want to let me have any visitation with my daughters, like on paper.
You claimed an exemption for a dependent when in fact that's not what the court order indicated. Is that correct?
Right. I don't know why I should have to pay for his attorney's fees. $1,000 is that's just out of my means. Like, it's just, yeah, I just don't want him to continue telling people that I don't help unless it's not deposited to his bank account or, to a, child support card, but I do help with my daughters.
Jessica Olson and Christopher Olson. So I have us on for, at least to the best of my understanding, 2 show cause contempt hearings. I have a motion hearing regarding the parenting plan, and also on for child support.
Generally, Your Honor, that's correct. I can give some say background. We were in front of the court, I think back in September. At least preliminarily, there were a series of dates pending. Miss Olsen had put the matter on with a docket notice to try and get a final parenting plan. No motion, and the requested relief was for a final parenting plan. That was addressed with the court, and the remaining dates were consolidated. My notes or recollection, we objected to the parenting plan modification because it wasn't properly before the court, and the court reserved on fees, but maybe wasn't clear whether it was the intention to move forward on that. Several weeks later, Miss Olsen did file a motion to modify the temporary parenting plan, but again, primarily requesting that a permanent parenting plan be entered. We did respond, don't believe it's appropriate to modify the parenting plan, but it's her motion. There's just a number of different things from both parties or all parties. We did also file an objection to her last declaration on October 30th that it should not be considered by the court. That was in the file when the matters were originally set over. The contempts, one by my client against Miss Olsen, one alleged by Miss Olsen against my client, I think both fundamentally address the tax exemption, and then child support. The parties agree child support needs to be set. There's just some issues on, I think maybe the date that it would begin or incomes. So I'll defer to Your Honor on how you want to proceed, but I guess think that's the general statement of what's in front of you today.
Okay. So it sounds like maybe let's start with, I believe that Ms. Olsen's motion to amend the temporary parenting plan.
Right.
And I think a couple things, Ms. Olsen, I will let you be heard here in just a minute. One of the things I did see was the October 30th declaration that you did file regarding the parenting plan, child support, and contempt. I will say it significantly is out of conformance with our, I know you're, okay, I'm going to start meeting folks. Ms. Olsen, your declaration is significantly out of compliance with our local rules. I know you're proceeding without counsel. Have you had an opportunity to review the local rules in our court regarding page limitations and the like in family law matters?
No, I did not. I didn't read up on any rules, so that's, I apologize for that. The last page was just a signature, and then one before that was just a signature, and it was over 2, and they never objected to that. And I wasn't aware of there was, a number of times you could respond. I wasn't aware of that because the last 2 times they waited until Friday, and so I was only able to do it on that next Monday. So so they were saying, it was not timely, even though, it's been 2 weeks now. So I do apologize about the page limit, but I mean, there has been time to review it. And I do discuss the contempt in there. I was going off of the old final parenting plan because when I came up to the clerk to get all of our papers, they left out the temporary child support, and that's where the tax exemptions are, set. And so I tried to go back and get the contempt back from them like an hour later, and they said that it had already been filed. So I addressed that in the last declaration that.
Okay. Well, I guess I am a little bit concerned when you tell the court you haven't taken the opportunity to review the local rules. Unfortunately, we still have to hold you to knowledge of the local rules, even though you are representing yourself. So I am going to strike your October 30th reply declaration. It is significantly out of compliance with our local rule requirements. I will not consider it for today's purposes. What I want to ask you first on your motion to modify the temporary parenting plan question that comes up for me, it sounds like one of the things you're significantly asking for is that it become that this court finalize a parenting plan. Is there something else you're asking for beyond that in your motion to modify the temporary parenting plan?
Well, our temporary one just says agreed upon by parties. There's no times, there's no anything. It's just whenever, now that the girls are a little bit older, they're 14 and 16. My oldest daughter is driving. I understand that they need to, be teenagers and be kids. But before she was driving, they were coming over to my house every weekend. And like the last 6 months or, since summertime, they come over maybe on Sunday afternoon for a couple hours. I just want them to, come to my house, and whether, I don't want it to be up to them. Like they can go to work from my house. They can go to their friend's house from my house. I just want to be able to hug them, and, FaceTime just isn't enough sometimes.
Okay.
So he does say that it's been working, and yes, but not the last 6 to 8 months. He says that, there was the respondent says that they shouldn't have to come over and put in their time like it's jail or something. And so I do realize, like I said, that they're growing up and, being teenagers and having friends and jobs and all that. But, they can, I just want more than, a few hours a week with my daughters. And he said it's been working, and it it not in the last some time. So
let me, Mr. Baldwin, your perspective on the the petitioner's motion to modify the temporary parenting plan.
Yes, Your Honor. So I maintain the same position when there was no motion. It's deficient in that the relief requested is finalizing a parenting plan that the court doesn't have the discretion to finalize at this particular point. With regard to the specific issues raised, if the court were to get to them, I do think my client's declarations establish sufficiently that there's no reason to modify what the temporary is. This is a peculiar, unique situation where a temporary order has been in effect since 2019. The parenting plan, it was entered on a temporary basis in December of 2019, gave custody of the party's son, who at the time was a minor and has since aged out, to mom, while my client had custody of the daughters, and the parenting plan language was the same for all children. The son was to have visitation with dad when agreed between the parents. The daughters have visitation with mom as agreed between the parents. It didn't become an issue to mom until the point came that the son aged out. And I think contemporaneous with all of this is the filings were made somewhat contemporaneous with being put on notice about a potential contempt related to mother taking the tax return of one of the daughters after my client instructed her not to because of the order of the court. So I don't think that there's any basis, even if the court were to consider the motion at this time, for the court to modify the temporary that has been in effect. And if the court does consider it on the merits that there's no justification or basis to make the modification at this point, if mom wants a final order, she can put the matter on for a settlement conference or trial, and it can get to the merits of the case ultimately. But this is the parenting plan that she had no issues with when she had the son, and now for whatever reason has become identified as an issue for her. So I think the motion is itself deficient, and even on the merits, there's no basis to modify the temporary order at this point with the information the court has.
Ms. Olsen, anything else you want the court to know on this specific issue?
No, so Mr. Baldwin sent me a letter back in August saying, that, hey, sign our papers and, we're gonna, charge you $560 a month in child support, yada, yada, yada. And, there's no, like, in the paperwork, there's no specific parenting time with my daughters. So I just wanted that to be, in writing somewhere that, I was able to, visit my daughters. Now, Mr. Olson and his lawyer, they want, over $1,000 in child support for me, but they don't want to let me have any visitation with my daughters, like on paper.
So,
yeah.
So ma'am, what it does sound to me like, and I agree with the arguments of Mr. Olson's attorney, in essence, what you're asking us to do is bypass procedures for a contested trial, mandatory settlement conferences, those sorts of things to get to a final parenting plan. So I am going to deny your motion to amend the temporary parenting plan. If you want to address those issues and have changes made, did she fall off?
No, I'm here.
Oh, you just turned off your camera. Okay. And that's fine. I've seen you. If you need to turn off your camera for bandwidth, you certainly keep it off. But you need to set this for a contested trial. So that is going to be my ruling on the petitioner's motion to amend the temporary parenting plan. Let's go to child support. And I'm just looking, did we have temporary child support orders yet?
Yes, Your Honor, that's part of the issue. Is back in the modification in 2019, the court set a child support order that factored my client's income because he had greater income, even though he was the primary parent of two children, ended up paying support to Miss Olsen with a transfer payment at the time of $220 a month because of their son that was in her custody. When their son turned 18, because it was a temporary order, support enforcement wasn't able to assist in basically fixing the support obligation. The offsetting ended when their son turned 18, but Miss Olsen was not and has not paid support for the daughters since that time. She didn't file the motion regarding setting child support, and it is accurate, Your Honor, as I had somewhat indicated. There was a letter as referenced by Miss Olsen indicating some of these concerns in an effort to negotiate a resolution. It didn't result in one; it resulted in her motion, which is why we have all these other motions. We did file a child support worksheet based on her income. She indicated in her motion she makes $25 an hour. I don't recall that we had a pay stub or anything beyond that to factor the child support amounts. So we did run worksheets based on income and came to a transfer payment of $1,043. We are also asking the court set, not based on those numbers, I don't think it'd be appropriate. The order that was in effect from 2019 had income amounts that would result in transfer payment from Miss Olsen to Mr. Olson for the daughters that remained in his care after their son turned 18. It's a little over 12 months worth of time that the court should order support retroactive from the amount in that order to any new order of the court, and that from the date of the effective new order based on our worksheet.
Ms. Olsen, have you had a chance to review I see you have filed a motion to amend child support as well as the respondent. I only have the respondent's proposed worksheets and order here.
Well, I've turned it in a couple times, so it should be in there somewhere. I put an updated one into the last declaration that, they wanted to strike. And since then, a couple weeks ago, I started a new job where I only make $20 an hour and I only get paid once a month at the end of every month. That's neither here nor there. $1,000 is just, that's just out of my means. Like, it's just, yeah. I mean, like I said, Mr. Olson makes $60, $81 an hour, and now I make $20. And I have no problem paying support for my daughters. I just initiated that to, show them that I don't have a problem. And, I gave a list of all of the, expenses that I've paid for them, in the last, few months. It was like $3,000. I just don't want him to continue telling people that I don't help. Yes, it's not deposited to his bank account or, to a, child support card, but I do help with my daughters, whatever they need within my means, like whenever they ask. I mean, they ask me for gas money. Our youngest daughter asks me for lunch money every day. I send that to her on Apple Cash. Literally, like I send her $10 like every other day for lunch. And it's $1,000 is just like I can barely like get to the grocery store as it is.
Here's what I'm going to do on the child support issue. Because I did strike your October 30th by declaration, which includes at the end of it your proposed child support worksheet. What I'd like you to do is to refile at the court rules to make sure that you're filing it in a way that the court will accept. And I'm going to set just the child support issue over 2 weeks if the parties are available. I believe is December 5th, if I'm not mistaken.
Okay.
And I also think looking just at respondents' proposed child worksheets, I do think that's a large amount of money to request in a transfer payment given the discrepancies in income here. So I want to give you time, Ms. Olsen, to really respond. So would both of you be available on the child support issue December 5th at 1 o'clock?
I am, Your Honor.
Okay. And Ms. Olsen?
Yes.
Okay. What I'm going to do, I know we have this short week this week. Could you get your reply declaration or a declaration of your proposed child support worksheets into the court and to Mr. Baldwin by next Tuesday, November 28th?
Yes.
Okay, I'm going to set that as your deadline for the financial information, okay?
Okay, so I'm allowed to submit another declaration even though they said that I've had too many in our case?
Just on the child support issue, I would like you to resubmit, but please read the local rules as it pertains to page length and that sort of thing. But I think it's a significant enough issue that can make or break people that I'm giving you the opportunity to respond just with your financial information, your proposed worksheet.
Okay.
Okay.
Thank you.
And then I think that leaves us with the contempt issue.
Yes, Your Honor. And it sounds like, I don't want to misspeak, that Miss Olsen is basically, is she withdrawing her contempt?
Yeah. Yes. Like I said, I tried to go get it back after I realized that that I didn't have that temporary child support, worksheet. And so they said that I couldn't get it back. So since I didn't call to check on it the next day, I didn't think that it would be heard or even seen or be approved.
Okay. So we can strike petitioner's contempt motion. Mr. Baldwin, it seems like what that leaves us with is, if I'm not mistaken, and again, I know I'm kind of coming into this 3/4 way down the case, it looks like it's your client's motion for contempt regarding who gets to take a tax credit here. Is that correct?
That's correct, Your Honor.
How does your client want to proceed on that issue today?
We're asking the court to make a finding of contempt and impose the requested attorney's fees and sanctions as well as remedy. So our contempt is based on the tax credit, as the court can see, is identified in the parenting plan and child support order that was entered on a temporary basis in 2019. Miss Olsen received their son who lived with them or lived with her primarily, and my client received both daughters. That was the operation of things until the son turned 18. My client, in his declaration in support of the contempt and attached text messages, found out that Miss Olsen when he tried to file his tax return, was rejected. He became suspicious and concerned that she would have claimed one of the girls. She didn't respond. He continued to text. She ignored him. Ultimately, filed his taxes without both children as set in the court order. It's a unique situation where it's not as though the current order is an alternating year where the court can make up for it by allowing additional years of claiming the children to my client. So he filed his taxes, and as a result of that, basically lost out in the benefit. So we're asking the court to find her in contempt, attorney's fees for having to bring the contempt. It also is a peculiar situation, Your Honor. Miss Olsen, in her declaration that was struck and in her presentation today, intended not to proceed on her contempt. We were in court more than once, and there was no direct withdrawal of the contempt, despite her claim that she went back to the clerks to try and rescind it. It was on the docket and on the record that both contempts were being addressed by the court, and so we had to prepare as though we were responding to her contempt, even though it was improper, and responding to all of this, even though significant portions of it didn't comport with the rules. At the very least, there should be attorney's fees as requested for the contempt. She herself identified in her prior recitation that she received notice via mail of a suggested resolution regarding this, and instead of negotiating or discussing, she filed to finalize the parenting plan and filed her own attempt to get a contempt against him for complying with the order she complied with for the prior 4 years. So we are asking the court to order her to amend her tax return, removing the exemption for their daughter Emma, so my client can refile with both exemptions pursuant to the order. That attorney's fees and civil sanctions are appropriate for, say, blatant disregard of the order that was in effect that she received at the time, and wasn't again an issue until their son was no longer eligible for her to claim, and she just unilaterally claimed one of the daughters without any legal authority to do so.
Okay. Ms. Olsen, let me just ask you kind of pointedly, it appears that this is pretty black and white as far as you claimed an exemption for a dependent, when in fact that's not what the court order indicated. Is that correct?
Right. So like I said, I had gotten all the copies, and I thought that, I was allowed to claim them because I didn't have the, child support, the temporary child support worksheet. So we discussed it, and he said, okay, this better not happen again. And so then 6 months later, he, got the attorney. And so that was his choice to get the attorney. Like, I don't know why I should have to pay for his attorney's fees. He got it not because of the contempt. He got it to, try and get me to sign something that I didn't think was fair. So that's why I opened it. But yes, I did. We discussed it over the telephone. He said, this better not happen again. I mean, he got 10,000 instead of 12,000. Like, yeah. So yes, I did file. Our old parenting plan said that we alternated, and Justin, you can't claim kids that are 17 or older. So I haven't been able to claim him for a couple of years in response to Mr. Baldwin.
Just a second. I'm just going back to that order. Give me just a second. Okay. What I'm going to find on that, and obviously taking into account the December 16, 2019 order of child support, which is very clear that every year Christopher Olson has the right to claim Emma and Elizabeth Olson. I will find that there was contempt by including Ms. Olsen's tax return. There's nothing in the record for me to find that it's not willful or intentional. I will find contempt on that matter. I'm going to, as far as sanctions for that contempt, I will order. I don't have an original order for contempt on this. I know it's been set over so many times that it probably was in the file at one point, but isn't any longer. So Mr. Baldwin, send over a new order.
Yes, Your Honor.
I can get that signed. I'm going to go back to your original request here. I'm going to order Ms. Olsen that you refile your taxes, taking out that exemption so that Mr. Olson can have his return accepted if that has not been done already. I will include costs of 105. I will include a civil sanction of 105. I will on attorney fees, the requested amount is 3,500. I'm going to reduce that to 1,500 in order that that be paid.
Okay, so 15 and then 105.
1,500 for attorney fees, 1,000 is a civil sanction, 105 in costs.
Okay. Thank
Anything
you.
else on these matters?
No, Your Honor.
Okay, thank you both. You're free to log out.
I can't afford child support. Like legally, like 1,600 for 4 kids. Like literally, I still have a whole nother child that I have to take care of. I'm literally on poverty line right now because I don't have money left out of my paychecks. You don't realize people have bills and other obligations. You just sit there trying to say that it's a big chunk of money left over, and it's not. Because I'm sitting here telling you that I'm having a hardship with the money, but you're telling me that I haven't put in enough to pay my bills. And I don't see how you can, you know what I'm saying, tell me I have more than enough to pay my bills and I don't. Like, how you supposed to survive like that? I just don't understand it, but okay.